My name's Ollie Cashman. I've been at Milners for 5 years and I'm the head of commercial litigation. Commercial litigation covers a wide range of disputes. We act for directors and shareholders in company disputes. We act in partnership disputes over their businesses where people have got disagreements. Any type of business disputes we can act. We act either for claimants or defendants. I also act in commercial property litigation where we're acting for landlords in disputes over the properties that they own, the leases and breach of covenants and any dispute arising out of their leases or their properties. We also act in professional negligence claims whereby a professional, either an accountant, surveyor, firm solicitors have done something wrong, causing loss. I also act in lots of contested probate matters, which are disputes arising out of where someone has died and a will and there's an estate and a dispute arising out of that. When clients come to us, the first thing that they want to know is what their prospects of success are. It's fundamental that we establish that early on. We take an early analysis of their case. We'll meet with them initially and give them a shopping list of the documents and the information that we need, and then we'll give them the early advice as to what their prospects of success is. And we work sort of closely with them to come up with a bespoke strategy to get what they're wanting out of the litigation. The cost of litigation is something that we are frequently asked about. Predominantly in Milners, we act on a private paying basis and we charge on an hourly rate. However, there are a number of funding options that could be available. One of the first things we will ask a client is to check any relevant insurance policies that they have. A lot of people may not appreciate that they have legal expenses insurance as an attachment cover to other policies of insurance, and that an insurer may pick up the tab. In other claims, where their prospects of success are good enough, we can look to offer a conditional fee, a no-win, no-fee agreement, or a contingency fee agreement, which is where we take a share of their damages. Ultimately, it will depend on what approach they want to take. If you're in the position where court proceedings are going to be issued, it can generally take a minimum of 18 months from the issue of the claim to the being at trial. If you're going to be fighting out to a trial, it will take a long time, and that's one of the factors that clients obviously have to consider in the approach they want to adopt to litigation. I've always enjoyed commercial litigation. I'm naturally a competitive person. I've enjoyed sports, played rugby since I was sort of knee-high. With litigation, there is obviously that adversarial element to it, but also the satisfaction you get out of getting a great result for a client, and whether that's sort of winning at court or even getting them a great settlement. We really do punch above our weight in terms of the size of the firm and the litigation that we are undertaking.